And now I remember why I never wear this shirt. And now it hits me. It's a green shirt. Not allowed to wear green. I wore green today, guys. Because that's my first day on the job, and I'm not changing. This is my shirt. Serious effort would be involved. I mean, now that I moved everything upstairs, my another shirt is right there. I would have to just go right there. But now I'm wearing green today. I have a lot of green. I'm Irish. This is a green shirt. It says lucky. I'm not allowed to wear it for work here today because it's green. Just, you know what? I'm wearing a green shirt. So, we're going to go to a new judge with a bow tie and an older judge in a new courtroom that we've seen once before. The new courtroom, anyway. Let's see. Alright, I guess we're starting here. It's already set up. I don't like this. How about we put us up here? There, that's good enough. Now we're out of the way. Okay. I am going to fast forward a little bit because this interpreter is so loud and it is too early for somebody screaming at us in a different language. I don't know where chat went. There we are. I didn't read chat this whole time and I was so worried I was going to see muted. I didn't, Josh.
Que por declararse culpable,
See?
usted está admitiendo que usted cometió un crimen, con lo cual usted ha sido acusado.
Sir, no. You don't have to have the microphone in your face. There's no reason for that. There we go.
Ms. Robles?
State the page managed workplace, cause numbers 20B01, 240 CM1189, 20B01, 409 CM15.
Goat.
Just
Back. Back, hi. How are you? Back. I wish I would have known you were stopping by. I would have had Judge Wolf ready for you. Son of a gun.
Sir, please raise your right hand. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court will be the truth?
I do.
Thank you. Please tell me your full name.
Jorge Jimenez Robles.
Thank you. The court shows the defendant appears in person and also by attorney Nolan Miller. State appears by DPA Colin Groover. And we are set today for a violation, I believe, of community corrections.
Correct, Your Honor. There's two cases. There's a, just for housekeeping, there was a violation and a couple supplements that were filed. At least one of them in each case was filed, I believe, after the initial. But we have an agreed recommended sanction, and as part of that, we just have him admitting to the first violation as a partial admission instead of the other two, so we don't need to hold a initial hearing on the other two supplements.
Thank you. Mr. Groover, do you have anything to add to that?
No, Your Honor, I would agree with that.
All right, Mr. Jimenez, is that correct? Or are you going to make a partial admission today?
Correct.
And sir, do you understand what Elkhart County Community Corrections has alleged that you have done in that first violation report?
I do.
Sir, do you understand that you are not required to admit that you violated your placement on community corrections and that you can instead require the state to do so?
I do.
And in the event that you denied that you violated your placement on community corrections, we will have a hearing. And at that hearing, the state of Indiana will present evidence, which typically happens through the testimony of witnesses. You have the right to confront and cross-examine any witnesses called to the state of Indiana at that hearing. Do you understand that?
I do.
You also have the subpoena power of the court, which means that you can require that witnesses appear at that evidentiary hearing and testify on your behalf. And the exercise of that right does not cost you anything. Do you understand that? You have the right to have an attorney represent you at that evidentiary hearing. So that means if you wanted to have that hearing, Mr. Miller would represent you at that hearing. However, if you are not able to afford his services for that hearing, I will appoint the Office of the Public Defender to represent you. Again, if you wanted to have the evidentiary hearing. Do you understand that?
I do.
And sir, you understand that if I find you violated your placement on community corrections, that I can revoke your placement on that program and require that you serve the balance of your sentences either at the Department of Correction or at the jail. And with everything that we've discussed today,
Thanks for the
do you still want to
cheers,
admit you
Kelly.
violated
Thank
your
you.
placement on community corrections?
Yes.
On a factual basis, please.
Thank you, Your Honor. Mr. Jimenez Robles, I want to take you back to January 6, 2025. Is it true that on that date, you were sentenced in two cause numbers, specifically 20D01 2407 CM 1189 and 20D01 2409 CM 1593 to a term of community corrections on Elkhart County Community Corrections?
Yes.
Elkhart County Community Corrections filed a violation petition on or about September 4, 2025, alleging that you traveled to some unauthorized locations and that you were late getting back to the facility from your approved pass. Is that true?
Yes.
So do you agree that by going to those unauthorized locations and not returning by the time you were supposed to return, that you violated the terms and conditions of your community corrections placement?
Yes.
I don't have anything further on a factual basis.
Mr. Gruber,
No questions, Judge.
the court will find the defendant has tendered a knowing voluntary admission based upon the factual basis. The court will find the defendant has violated the terms and conditions of his placement on community corrections by being in an unauthorized area. All right, Mr. Miller, arguments on your client's behalf, please.
Thank you, Your Honor. The agreed recommended sanction is there's two cases here, cause number ending 1189 per my calculation, including today's date, he has 181 days served on this case. So he's only, and what I was showing with ECCC's reports themselves, they had an out date of, I believe, October 8th. So we're only a couple days away from that being finished out. So we had agreed that that would just be finished out. And then we're recommending jointly that he return to work release on cause number ending 1593, which does not have any credit time. So his out date on that one's on or about April 9, 2026. I'll note that there was a third cause number that he previously served at ECCC on work release. I brought the final report with that with me today. He had gotten a satisfactory discharge from ECCC back in April. He's been there since approximately January 7th, 2025. So he's made it, about 8 or almost 9 months with pretty good conduct and doing a really good job. And he completed, I brought this as well today, and I think it's in one of the reports, but he did complete MRT domestic violence through ECCC on or about August 7th. He still has full-time employment that's waiting on him. He has court-ordered parenting time, which has been difficult to exercise, but he does have court-ordered parenting time and court-ordered
Monica,
child support
thank you for the
obligation, which he
cheers.
recently, I
Thank
think
you.
last month, got his contempt that was pending in the 4D court discharged because of his compliance with paying his child support. This was a situation where he had been doing very well at ECCC for a long time. He's been serving 3 cases, and he had a day where he just kind of had a little bit of a mental break, and he went out and he didn't come back when he was supposed to. But I think what's crucial in this instance is that he did what a lot of people don't do, and he did come back. I know in my experience, a lot of people, when they get in that spot, they unfortunately tend to go AWOL, but he did come back, turned himself in knowing he was going to go to jail. So I think he's demonstrated that he can be accountable, and he's going to take this seriously. And this has been a wake up call for him. And he's ready to go back and get back to life and his children and his obligations. So we're asking that the court adopt that recommendation and put him back at work release.
Mr. Miller, Mr. Jimenez, is there anything you would like to say on your own behalf?
No, not at the moment.
Arguments from the state, please.
Your Honor, I would agree with all of the comments of counsel.
I don't know about this one, guys. At first, I was wondering why we were even here. He was late getting back, but he did go AWOL. But then he went back. We've had people who got to keep work release for much, much worse crimes than what this guy did. But I don't know. I mean, they're letting you do this instead of staying in jail. Why would you mess it up like that? If he's gonna mess up like that, like, he doesn't care. I don't know about this one.
Just ask the court to accept the recommendation.
All right, thank you. So based upon the information provided, the court will accept the joint recommendation of the parties and show that as a sanction for the defendant's admission to the violation of Elkhart County Community Corrections in cause number 20D01-2407-CM1189, that the defendant be unsatisfactorily discharged from Elkhart County Community Corrections. So I think I read this last week. There was a case that I think came out that clarified the issue of when you're dealing with a 1-year sentence and it's an odd number, 365 days. And I see that it was calculated to show 183 days actually served. Well, obviously when we double that, it's a day over. And I believe the Court of Appeals clarified, and it's not a certified opinion yet, that you round down. So I still think, just in good conscience, that it would make sense to go ahead and do that here, unless there's some strong opposition from the state.
No, Your Honor.
Okay, so the court will show that the defendant is time served as of tomorrow, applying credit time. Mr. Jimenez, I tell people here all the time that everybody makes mistakes, everybody does dumb stuff. And it certainly was a mistake for you to, for whatever was going on with you, to get frustrated and exceed the terms of your placement. But what's important from my perspective is what you do with that mistake. And the fact that you came back tells me that you are a person that is certainly capable of being rehabilitated. So we have to afford you that area or that room to grow and learn from your mistakes. And hopefully this is one of those opportunities for you. So because of that, I will order for the other sentence that is in cause number 20D01-2409-CN1593, that there will be no sanction imposed and that you will be placed on Elkhart County Community Corrections at a level of supervision deemed appropriate. So, Mr. Jimenez, we will notify Elkhart County Community Corrections that you've been placed back on their program, and they will either transport you to the work release facility or outfit you with the ankle monitoring device, whichever they believe is the appropriate level of supervision. Do you have any questions about that?
No, Your Honor.
So I will show the appearance of Attorney Nolan Miller is withdrawn of all causes of action.
So he was unsatisfactorily discharged from this probation, time served. He still has the other case, but because he was unsatisfactorily discharged from this one, it'll be harder to get probation next time. He probably still will, though.
Are vacated. Mr. Miller, is there anything further?
No.
No, Your Honor.
That concludes the proceeding. Thank you.
Kate Bengelmeyer.
Bobby, you know who else was an angel? Never mind.
This is cause number 20-1-505-310, State of Indiana versus Chase Engelmeyer.
Coffee's here. I'll be right back.
Good afternoon, Your Honor.
Good afternoon. Sir, please raise your right hand to be sworn. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court will be the truth?
Yes, ma'am.
Thank you. Go ahead and have a seat, please. And please tell me your full name.
Chase Tanner Engelmeyer.
Thank you. The court shows the defendant appears in person and also the attorney Eric Kinsman. The state appears by DPA Colin Gruper. And I show that we are set today for a change of plea hearing. And we also need to address the state's motion for leave to amend the charging information. So counsel, I will defer to you on what to handle first.
Your Honor, I suppose the state's motion to amend, if that has not been addressed, I'm happy to address that. I'd wait further reading of it. DPA Leong provided me with the amended charge. And frankly, those are the charges that we're working through right now. Whatever record the court wants to make on that, I don't have any legal objection to the amendment.
The court showed that the motion for leave, state's motion for leave to amend is granted without objection, and that the defendant waives any formal initial hearing on the amended charging information.
Having said that, Your Honor, there has been discussion about further amendments. However, Mr. Leong and I believe that we can resolve this case by agreed disposition, not by trial. And frankly, we've got the framework of a disposition. And I'm asking, I've discussed this with Mr. Leong, I'm asking for 2 weeks, October 20th, to set this matter for further change of plea. I believe we'll have it resolved at that time.
Monica, I'm so sorry, Monica. When I first start my stream, I have things I want to say. But when I actually do press the go live button, I forget everything. And then when I saw that my shirt wasn't showing up at all because it's freaking green, I actually forgot everything. Monica, thank you for the PayPal. Appreciate it. I really, really appreciate it. Thank you so much.
Before I hear from the state, Mr. Kinsman, 2 weeks from today is, I'm showing fairly heavy, and it's an interpreter date. So October 27th.
Your Honor, for the record, Mr. Leong and I were very clear that I was going to ask for 2 weeks. And I did put to him the question, well, if the court sets it at a different date, that won't be on my motion. But I'll agree to the whatever date the court sets, and the 27th is open for me.
Your Honor, I did speak with DPA Leong, and we are fine with setting it on the 27th rather than the 20th.
Okay, and it's certainly due to the court's availability or lack thereof. So I will show a motion of the defendant and without objection by the state. This cause of action is continued to October 27th, 2025 at 1:30 p.m. I will show that the delay is chargeable to the defendant for purposes of criminal report.
Thank you, Your Honor.
Thank you.
Brian Thompson.
State of Indiana versus Brian Thompson, cause numbers 20B01-212F61583, 20B01-2409F61146, and 20B01-2507CM1148. Mr. Thompson, please raise your right hand to be sworn. Do you swear or affirm under penalty of perjury the testimony that you provide to this court will be the truth?
Yes, ma'am.
Thank you. Please tell me your full name.
Ryan Lee Thompson.
Thank you. The court shows the defendant appears in person and also the attorney Freeman. The state appears by DPA Colin Gruper. And I show that we are set today for a change of plea hearing for the 2 new cases and further proceedings for a violation of community corrections. Ms. Heeman, last week you had filed a motion to dismiss the habitual criminal offender enhancement. So I'm not sure where we need to go from here.
Your Honor, I think depending on what the court rules on that motion to dismiss, that may well affect our plea negotiations. So today I would ask to continue the further proceedings date or the entry of a plea date and either have a hearing or wait for the court's ruling on the habitual motion.
Certainly I have to give the state a chance to respond.
Your Honor, I have looked at the motion and I actually would agree, I'm in agreement with Ms. Heeman. So the state is going to dismiss the habitual enhancement on that.
All right, so the court will show on motion of the defendant and with agreement by the state of Indiana, state agrees to dismiss the habitual criminal offender enhancement. And that's with prejudice, correct?
That's correct.
All right, so Ms. Heeman, you are asking for a continuance.
Yes, and Mr. Thompson just brought up the point that with that being dismissed, that hopefully will affect his bond and maybe allow for a lower bond. And also the probation violation case, let's see, that is the one ending in 1583.
It's a community corrections.
Sorry. The community corrections violation case will be served fully in November. So he thinks that might affect bond as well, the risk being much lower that he would not come and deal with.
He's not eligible for bond yet.
Say that again, please.
He's not eligible for bond yet. Because of the community corrections violation.
I think the court could set a bond. He hasn't had a disposition on that case yet.
Okay. I'm not going to reconsider bond, but I can set as quick as a hearing as I can.
Okay,
So 3 weeks from today.
whenever you can, Your Honor, that will be fine, please.
Is there any objection from the state?
Is that just to do a
Sounds like we may
bond
well have
review
a
or a
plea.
change of plea?
Could go either way, depending on where
Sure.
we're at.
Okay. Yeah, that no objection, Judge.
Depending on what the state tenders, we'll go from there
Okay,
when we come back.
okay.
All right, the court will show on motion of the defendant and without objection by the state. These causes of action are continued to October 27th, 2025 at 1:30 p.m. The court will show that in F6-1146 and CM-1348, the delay is chargeable to the defendant for purposes of criminal rule. Anything else?
No, Your Honor, thank you.
Thank you.
Sometimes they can do it. I know, because I did Anthony Dye's case. That was my case. I know. We either do a plea that day or a bond. Okay. You're welcome. Thank you, Your Honor.
Jonathan Singleton.
Number 2001-507 CM-1349, State of Indiana versus Jonathan Singleton. Certainly, raise your right hand to this form. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court will be the truth?
Yes.
Thank you. Please tell me your full name.
Jonathan Michael Singleton.
Thank you. The court shows the defendant appears in person and also with attorney Teresa Heeman. State of Indiana appears by DPA Colin Groover. And I showed that we are set today for a change of plea hearing. And it looks like we had a plea agreement filed back in September.
My notes indicate it's a sentencing hearing, Your Honor, from PDIS.
Right, I looked at the wrong thing. Sentencing hearing, I apologize. All right, that was having deja vu here. All right, so we have some eligibility reports filed. And Ms. Heeman, do you have the credit time calculated?
I do, Your Honor. It's exactly 100 days as of today.
All right, Ms. Heeman, are you prepared to make arguments on your client's behalf?
Thank you, Your Honor. Our plea agreement calls for a total sentence of 2 years with 1 year on each count at alternative placement executed at community corrections. And Both programs have found him to be eligible. We would like to request MCC because he's had some other dealings or some prior, I guess, experience with MCC and knows that they will permit him to live with the victim in this case.
Well,
and that if
I
the
think
court
it should be a court
please,
approval.
if the court allows, and if that is an okay condition, he would like to ask about that or do that. There are no prior batteries on his record, no prior crimes of violence. This is a case, Your Honor, where the parents wrote a letter and filed it with the court. His father, Jack, said that he does want Jonathan to come and live there, and that is in the letter that got filed with the court. We're also hopeful, Your Honor, that you would at least consider allowing him to be released prior to hookup. I know that's not always the court's policy, and I did explain that. But he wanted to ask because he's already done 100 days. Also because these are both misdemeanor matters, and also so he can have a job lined up first. So those were his thoughts, that it would be much easier for him to have a job already there in place when he gets hooked up.
Nothing
So
good,
we are
Jenny.
grateful for the
Nothing
plea and we
good.
think it's
Hi,
appropriate.
Helen.
That's
How
all.
are you?
Thank you.
Thank you, Mr. Singleton. Is there anything you'd like to say on your own behalf?
No. No, Your Honor.
Arguments from the state, please.
Thank you, Your Honor. Well, as the court is aware, this is a different type of domestic battery situation than oftentimes we have. It doesn't involve intimate partners, but rather a son and his parents. We do think community corrections is appropriate here, given Mr. Singleton's his history. We have had communications with Mr. Singleton's parents. They are not, they were pretty adamant in terms of their feelings about the case and wanting him to be able to communicate with them first and then be able to live with them as well. So we're not going to ask for a no contact order. The state is not objecting to Mr. Singleton living with his parents in this case, but obviously would defer to the court.
Thank you, Mr. Groover. Based upon the information provided, the court will accept the defendant's plea agreement and will sentence the defendant according to the terms of the plea agreement. On counts 1 and 2, both of which are domestic battery as Class A misdemeanors, the court will sentence the defendant on each count to 1 year at the Elkhart County Correctional Facility. And because these are consecutive sentences, the court will award the credit in count 1 only. That is 100 days plus equal good time credit. And for the remaining portion of that sentence, the court will authorize alternative placement on Michiana Community Corrections. The court will order Mr. Singleton that as a condition of your placement on Michiana Community Corrections, that you participate in any programming or treatment that your case manager believes will benefit you. Do you understand that?
Yes.
The court will also permit the defendant to live with the victims in this cause of action, subject to their approval. The court will make a domestic violence determination. Mr. Singleton, what that means for you is that you are prohibited from possessing firearms and ammunition. It means that you may also have restrictions in parenting time with minor children. Do you understand that?
Yes, ma'am.
The court will impose the mandatory court costs only. No additional costs will be imposed. The court will show that the appearance of the public defender's office is withdrawn, any future hearing dates are vacated, and that judgment of conviction is entered on domestic battery as Class A misdemeanors on both counts 1 and 2. Mr. Singleton, it's only in the rarest of circumstances that I will allow somebody to be released to report, and unfortunately your circumstances don't warrant that. So we will contact Michiana Community Corrections. It usually takes them a matter of a couple of days, if that, to hook you up. So as soon as they hook you up, you'll be released.
Okay.
Ms. Heeman, anything further?
No, Your Honor, thank you.
Mr. Groover?
Nothing, Your Honor.
All right, thank you.
Christopher Morris.
This is cause number 20-01-240 F6272, State of Indiana versus Christopher Morris Jr.
She sent me an email, so I'm
Mr. Morris, please raise your right hand to be sworn. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court will be the truth?
I do.
Thank you. Please tell me your full name.
Christopher Kyle Morris Jr.
Thank you. The court shows that the defendant appears in person and also with attorney Teresa Heeman. The state appears by DPA Colin Gruber. And I showed that we are set today for further proceedings on a violation of Elkhart County Community Corrections. Ms. Heeman.
Your Honor, we had met and talked about the violation that's filed and had a position we were going to admit with explanation. However, on Friday night, I got an email from Ms. Rich, the prosecutor, who indicated that there might be a new charge, that the office has currently received a new uncharged case for him. It's being reviewed by the Superior Court for prosecuting attorney. And so, and she thought it might have something to do with the basis of the violation. With that knowledge, I don't feel comfortable going forward with making an admission till we know a little bit more. I know Christopher doesn't feel comfortable sitting in jail a long time waiting and wondering. I guess, Your Honor, we've asked to consider a bond or to ask for the matter to be set again in a short time and see what the status is.
Well, in light of the allegation, I'm not sure that Elkhart County Community Corrections would want him back. And he's under a sentence.
It was his cousin and it was horseplay.
Well, Heeman, I would recommend that you not admit to it on your client's behalf.
Thank you, Your Honor. I understand.
But regardless of what the explanation may be, like there might potentially be a new charge coming as a result of that, albeit I'm not sure why in Superior Court 4. It seems to not make sense.
Right.
So either I transfer the violation there, or then this comes here. I don't know why, when they're connected, we would have them in two separate courts, but.
Your Honor,
Anyway.
I'm not sure the nature of the new case.
It's alleged that he was in a fight at work release. And that's why we have the violation. And I would assume it's a battery charge. This may be being reviewed.
If it's a misdemeanor battery, it would, I do think it would have to go to probably traffic and misdemeanor.
The new local rules are in effect, so I don't think that's correct.
Okay. Yeah,
They were approved last week by the Supreme Court.
okay. Yeah, I will have to check on that. So, if that's the case, then we'll have it sent to, probably to Miss Rich.
Okay.
So they have certain rules. Cases.
Well, I think because we need to kind of expedite this case and find out what's going on, I'm willing to look it in 2 weeks from today, October 20th.
Yes, please, Your Honor.
Mr. Gruber?
That works for the state.
All right, the court will show on motion of the defendant and without objection by the state. This cause of action is continued to October 20th at 1:30 p.m. Anything else, counsel? We need to get some evaluations.
Yes, please, Your Honor. Let's do the community corrections for both MCC and ECCC.
The court will order that Elkhart County Community Corrections and Michiana Community Corrections evaluate the defendant for possible placement on their programs.
Thank you, Your Honor.
Thank you, Scenario. Thank you.
Gates locked.
This is cause number 20-01-2505F6564, State of Indiana versus James Lawson Jr. Mr. Lawson, please raise your right hand and slowly. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court will be the truth?
Yes.
Thank you. Go ahead and have a seat. And please tell me your full name.
James Lawson Jr.
Thank you. The court shows that the defendant appears in person and also with Attorney Teresa Heeman. The state appears by DPA Colin Gruber. And I show that we are set today for a change of plea hearing. Ms. Heeman.
Judge, we have not reached a plea agreement with the state. That could still happen, but I think we're asking at this time for a trial date.
Assuming we would be looking into January or February of next year.
That's fine, Your Honor.
January 13th.
That's fine.
Does that work for the state?
Yes, Your Honor.
The court will show at the request of the defendant, the court will set this matter for a trial by jury on January 13, 2025 at 2026 at 8:30 a.m. The court will set aside 2 days to try the matters at issue. I will also set a final pretrial conference. And I will do that on December 15th at 1:30 p.m. Mr. Lawson, do you acknowledge or understand that I set your case for a trial by jury on January 13, 2026 at 8:30 a.m.?
Yeah.
And do you further acknowledge or understand that if your case goes to trial on that date, and if you are voluntarily absent, which would include the refusal to be transported to the courthouse for that trial, means that we will go forward without you?
Yes.
Thank you. Ms. Heeman will keep you updated on any changes, but we'll see you back here on December 15th for that final pretrial conference.
All right.
Thank you.
Because
Thank you,
the
Your
other
Honor.
hand is on the steering wheel.
Joshua Conley. Go to the jail.
Clause number 20-01-2310-F6.249, State of Indiana versus Joshua I.M. Conley.
No, Sandra, no working, please. Please. Not today. We have off today.
Mr. Conley, raise your right hand, please. You swear or affirm under that this court will be the truth?
Yes, sir.
If you have a seat. And please tell me your full name.
Joshua Isaiah Marshall Condon.
Thank you. The court shows the defendant appears in person and also with Attorney Kelly Schweinsker. The state appears by DPA Colin Gruber, and I show that we are set today for further proceedings on a violation of probation matter. Ms. Schweinsker.
Your Honor, he'll admit to the violation.
Mr. Connolly, is that correct? Are we going to admit today that you violated your placement on probation?
Yes, Your Honor.
Mr. Connolly, do you understand that you don't have to admit that you violated your placement on probation and
Yes,
that you
ma'am.
required state proof? Okay, you required state proof that you did so?
Yes, Your Honor.
Sir, in the event that you deny that you violated your placement on probation, we will have a hearing. And at that hearing, the state of Indiana will present evidence, which typically happens through the testimony of witnesses. You have the right to confront and cross-examine any witnesses called and stated at that hearing. Do you understand that?
Yes, Your Honor.
You also have the subpoena power of the court, which means that you can require that witnesses appear at that evidentiary hearing and testify on your behalf. And the exercise of that right does not cost you anything. Do you understand that?
Yes, Your Honor.
Mr. Conley, you have the right to be represented by an attorney at that evidentiary hearing. So that means if you wanted to have that hearing, Ms. Schweinsberg would represent you at that hearing. If you were convicted at that hearing and you wanted to appeal your conviction, I will appoint the office of the public defender.
All right, I'm gonna say it. I'm gonna say it. The old courtroom is so much better. Her verdicts were so much better in the old courtroom. She was so much stricter in the old courtroom. And I thought she had blonde hair. She has gray hair. I miss the old courtroom. It was better.
I was distracted by Officer Shootman chewing on something behind me.
Apologize, Your Honor.
Oh, sorry. I just was wondering what it was.
I want to
Ms.
know what
Schweinsberg,
he's
this is a
eating. What is he
public
eating?
defense,
I
right?
wanna
Yes,
know.
Your Honor.
All right. I was also trying not to laugh. All right, Mr. Conley. So if you wanted to have the evidentiary hearing, Ms. Schweinsberg would represent you. Should also help you with preparing for that hearing. Do you understand that?
Yes, Your Honor.
Mr. Conley, do you understand that if I find that you violated your placement on probation, that I can revoke your placement on probation and order that you serve the balance of your suspended sentence?
Yes, Your Honor.
And with everything that we've discussed, do you still want to admit you violated your placement on probation?
Yes, Your Honor.
Thank you, factual basis, please.
Thank you, Judge. Joshua, you were sentenced in this court back in December of 2023, is that correct?
Yes, Your Honor.
And
Yes. My bad.
a term of probation is that you're not to be charged with any new offenses while under supervision, is that correct?
Yes.
Do you admit that on August 23rd of 2025, you were charged with battery as a Class B misdemeanor out of Elkhart City Court, and you were convicted of disorderly conduct out of that case, is that correct? You were sentenced to 1 year of probation on that charge, is that right?
Mhm.
And that's to, is that yes?
Yes. Sorry.
And that's to run after this case is over, correct?
Yes.
And then also, you obtained your addictions assessment at Addictions Recovery Center on July 1st of this year. They recommended individual counseling, but when your probation officer spoke to them at the end of August, they had said you hadn't started your treatment yet as of when they talked to them on August 28th. Is that correct?
Yes.
Okay, and then also, they had filed saying that you hadn't reported that you had a stable job at the time that they filed this as well, correct?
Yeah.
We'll talk to the judge about all this though.
Mhm.
Do you understand?
Yes.
Yes, and you admit that those are violations of the terms of your probation, correct?
Yes.
Nothing further on a factual basis.
Mr. Groover?
No questions, Judge.
Thank you. The court will find the defendant has tendered a knowing voluntary admission based upon the factual basis. The court will find the defendant has violated the terms and conditions of his placement on probation by committing a new criminal offense and also by failing to timely complete any treatment. Ms. Schweinsberg, arguments on sanctions, please.
Thank you. Judge Joshua and I had talked about,
It's just so weird seeing Miss Schweitzger in here because I only see her in Christofino's courtroom, and she's in this courtroom. It's just weird hearing her call her out.
what was going on in his case, and he actually said that, this time that he's been on probation, he's actually made a lot more progress than other times that he's been on probation, even though there's been this violation. I think it's also important to note, though, as a side note, we were in court back in May of 24, and although technically it was listed as a violation, and he definitely knows that even though you're not actually reporting, it's filed as a violation. He was serving another sentence on home detention on a consecutive case. And there was a violation filed in that case, which also looked at as a violation in this case as well. But he hadn't technically started reporting on this case. So we just wanted to make that distinction. But since reporting on this case, this is what he considers his actual first violation. But since that time, he was actually working a good job, and he was working on a mowing crew. And according to this, what he was explaining to me, it was like this 7-week gig where he would go on these jobs, and he would be gone doing these gigs,
On the highways.
mowing on the
Yeah,
highways.
for the state of Indiana. We had a contract for 2,000 miles.
Okay, And so, he said he kept in contact with his probation officer. He told her about this. He actually had to reschedule some of his appointments because of the work schedule that he had. So, he didn't get a violation for missing appointments, because he did keep in contact with her and rescheduled appointments because of his work schedule. That's also why he had not actually began his treatment yet. He did the evaluation, but he didn't actually start the treatment yet because he was waiting for the 7-week contract to be up. And he knew that once that 7-week contract was up, he would have some free time to start his individual counseling. The misdemeanor, yes, he was convicted of disorderly conduct on that, but not the actual battery, and he does have a year probation to serve after that. Since he's been in the jail, I have a number of certificates. He has been working very hard since he's been in the jail. He's completed anger management, learning your strengths from shining light, domestic battery, foundation for recovery, a guide through the 12 steps of recovery, parenting while incarcerated, navigating conflict. And he's on right now 7 steps to be a better man, a better partner, and a better dad. So he has kept himself.
There's too much for anxiety.
Oh, the anxiety, I thought that was part of it. Anxiety and anger classes. He has kept himself very busy while in the jail. He wrote down a list of things he's been doing while he was not in jail, which was maintaining a job, getting a church, doing his assessment, getting an apartment that he had at the time, and then this job that he had working for mowing the highways. He does have a bit of a living situation problem, and so, while probation was recommending community corrections, he doesn't feel that's a good placement for him because he's, probably going to be living at the Faith Mission, and so he doesn't want to set himself up to fail. He's been incarcerated since August 23rd, and through today's date, that would be 45 days jail. We're asking you to consider placing him back under probation supervision and possibly ordering some community service hours, if necessary. But I feel that Joshua is on the right track and he will get out and he will do his treatment. He did his assessment, and I think that he will do his treatment. He's gonna have to do classes, I'm sure, for the battery charge out of Elkhart City Court as well. So that's what we'd be asking for today. Thank you.
Mr. Conley, is there anything you'd like to say on your own behalf?
I would just like to apologize for messing up this chance that you've given me. I'm hoping that you'll give me one more because I was like Ms. Kelly was saying, I was actually doing very well. I'm not saying that I'm super proud of myself, but I'm proud of how far I became in this past 1 year since being released last time. I achieved a lot in 1 year, and I've seen that I'm able to do it, so I know I'm able to regain it again.
Thank you. Arguments from the state, please.
Your Honor, the state is asking the court to adopt probation's recommendation that Mr. Conley be revoked and placed on community corrections. I understand the argument that he doesn't necessarily have a place to live. I guess the state's suggestion would be, work release might be the appropriate placement. That being said, if the court chooses not to put him or choose not to revoke, I think the state is, would ask for, something like community service or something to that effect, maybe CALP, as an additional sanction. But I would defer to the court.
All right, thank you. So counsel, one of the things I've been doing is reviewing the probable cause affidavit for the case, Mr. Conley, in which you were sentenced out of Elkhart City Court. And it seems like it was kind of a mess. The alleged victim of the battery appeared to be intoxicated and aggressive. Is that fair to say?
Yes, ma'am. I was trying to feed him a ramen noodle. He was upset that it wasn't a cheeseburger from Steak and Shake. I know it sounds hilarious. I'm sorry.
No, I don't think it's
you know,
It's
but
just no good deed goes unpunished is what I was thinking.
yeah, oh, well, that's a better way of saying it. But like I said, I just tried
I
to
think
be
it's
the kindness out of my
hilarious.
heart, cause like Miss Kelly was saying, I did join a church, Grace Community Church here out in Goshen. I joined a group through them called Fight Club. It's a church group. And it's really helped me a lot. And that was what's helping my addiction.
They got a church group called Fight Club. I betcha there is absolutely no rule about staying very quiet about what happens in Fight Club. I betcha they're supposed to go tell everybody.
I've been clean, you know, ever since December 9th. Because as you know, my mother did pass away and her birthday and stuff passed. And that was our first Thanksgiving and stuff without her. So I did go through a struggle, but I knew I was wrong. I even admitted to it. She didn't want to give me a drug screen at first, but I admitted to it because I knew I was wrong. And that's what came of the assessment needing. But I do,
Well, the incident at Steak and Shake, the
He's talking
gentleman,
about the treatment that he's going through, I think. Is that-
yes.
yeah, I'm talking about through everything, you know, I'll kind of, you know, repeat it a little bit. That's, you know, like I said, it just, I've did a whole 180 from the last time I've been in front of you, Your Honor. I'm not that same aggressive person, you know, in that situation, I thought I was protecting myself. You know, I knew where I was wrong because I thought, you know, me keeping them there at the situation was, you know, hey, this might, you know, show that he's better in himself, but there was a certain way I had to do it, and I feel bad I had to do it that way, you know, because I didn't want to put my hands on him. I really honestly wanted just to give him a soup and then fill up my tank, you know, with gas and then go back to work the next morning. But like you said, I can't remember exactly how you worded it, but yeah,
No good deed goes unpunished.
yeah, like that.
All right. Mr. Conley, my reading of the probable cause affidavit substantially corroborates the information that you've provided to the court. Mr. Connolly, I think you have come a long way. It's not great that you are here before the court again, but as I often tell people, I would never want to be held to the standard of perfection, and I'm not going to hold anybody else to that standard either. So, Mr. Connolly, I believe the amount of time that you have served in jail to be sufficient sanction. In the transfer, did you tell me what that was?
It's 45 days, August 23rd through October 6th. 45 days.
So it would actually be through yesterday, but, or I don't know. Does the state have any opposition to 45 days?
No, Your Honor.
The court will award the defendant credit for 45 days served plus equal good time credit and will order that you be returned to probation. Mr. Connolly, same terms, and you are going to have to get in touch with your probation officer upon your discharge. And probation is in this building now. Everything's combined in this building. So you will need to come in and meet with your probation officer.
Is it the same probation officer or?
I'm not sure.
Okay, I'll just come and report.
So once you are released, you need to report to probation and get an appointment scheduled. Do you have any questions?
Thank you.
The court showed the appearance of the public defender's office is withdrawn and any future hearing dates are vacated.
Walter, love, you're so early this morning. I thought I was late for OJ for a second.
This is called for
Walter.
0124.
Walter, were you there? Were you there for OJ? When the glove was done, like 2 days ago? It was really good. If you weren't there, it was really good. I haven't seen them, Sandra.
077. Indiana versus Philip Page. I thought he was eating a candy cane. That's why I started laughing. I don't know why it looked like a candy cane.
Maybe.
A gum, maybe.
For the
I think it was,
record,
oh yeah.
I love candy
Yeah,
canes. I
the
love them.
idea
They're
of
awesome.
Shoot, pulling a candy cane out of his pocket. It just amused me greatly.
Judge. Are you?
Good, how are you?
Mr. Cage, raise your right hand if you sworn. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court will be the truth?
Yes.
Thank you. Please tell me your full name.
Michael Page.
Thank you. The court shows the defendant appears in person and also with Attorney Colin Poinster. State appears by DPA Colin Ruber. And I should you're set today for a hearing on a violation of, or is it?
Probation.
I thought it was probation, but it wasn't titled that way, so I just wanted to double check. All right, Ms. Schweinsker, what are we doing?
You will admit, Your Honor.
Mr. Page, is that correct?
Yes.
Sir, do you understand what probation has alleged that you have done to violate your placement on their program?
Yes.
Mr. Page, you are not required to admit that you violated your placement on probation. You can instead require that the state prove that you violated your placement on probation. In the event that you denied that you violated your placement on probation, we will have a hearing. And at that hearing, the state of Indiana will present evidence, which typically happens through the testimony of witnesses. You have the right to confront and cross-examine any witnesses called to the state of Indiana at that hearing. You understand that? You also have the subpoena power of the court, which means that you can require that witnesses appear at that evidentiary hearing and testify on your behalf. And the exercise of that right does not cost you anything. Do you understand that?
Yes.
Sir, you have the right to have an attorney represent you at that.
See? That proves it. Horses and cows love candy canes. You gotta trust animals, guys. Animals know better than us. They're smarter.
Evidentiary hearing. So that means if you wanted to have that hearing, Ms. Schweinsberg would represent you at that hearing. She would also help with preparing for that hearing. Do you understand that?
He does look like the last
Mr.
guy.
Page, do you understand that if I find that you violated your placement on probation, that I can revoke your placement on probation and order that you serve the balance of your sentence at the jail?
Yes.
And with everything that we've discussed today, you still want to admit that you violated your placement on probation?
Yes.
Thank you, Ms. Schweinsberg. Factual basis, please.
Thank you. Philip, you were sentenced out of this court January 31st of 2025. Is that correct?
Yes.
You signed the terms of your probation the end of February of this year. Is that correct?
Yes.
And on June 6th of 2025, you met with your probation officer for an appointment and you filled out information. Is that correct?
Yes.
But after that, you have not had contact with the probation
No,
department.
absolutely not, Chinny. I need the goats to clear out my backyard. They can't be filled on candy canes. By the way, if anybody has a goat I could borrow for 8 hours, that would be fantastic. I live in Lancaster, freaking Pennsylvania. It is farm country. Everywhere around me are farms. Farms. Amish farms, Mennonite farms, just farms everywhere. When I drive on a road, I have to watch out for road apples on every road I drive. And if you don't know what road apples are, then you're good. Don't worry about it then. I should be able to get a freaking goat to rent for 8 hours. I don't know what the problem is. But you can do yoga with goats in Lancaster. You could, go to petting and pet goats in Lancaster, but you cannot rent a goat. I would have to go an hour outside of outside of Lancaster County to get a goat, which is crazy because all we have are farms around here. I swear we have a lot of goats. We have so many cows, it's not even funny. Which makes me wonder why milk is so freaking expensive here. We have so many cows. Why is milk like a rent payment? We have so many chickens. Why are eggs as expensive as a freaking Lamborghini? I don't understand. I need someone to explain this to me. Actually, you know what? So all these farms around here, they must have these big mega contracts with the groceries. To get rid of their milk and their corn and their eggs. But I bet you if, as a community, we reached out to all these farms, I was just like, hey, Instead of like, you just selling it to Giant and Giant marketing it up 700% and then selling it to us, can't you just sell it to the community? We will buy your stuff from you. You know us. Your kids go to school with our kids. No, because the Amish kids go to the Amish schools. But still, I mean, yes, you can. I can stop by. We have a lot of road stands. A lot of road stands. But if they would just make it like a community place where we can support our farmers, and the farmers can sell us stuff that's not like $50 for eggs, but we need to make it easy for them. So we would need like a group in the community to create a space for them to set up their wares and everything. We do have a farmers market. A huge farmers market. Actually, we have one big one and some small ones. But that's not, it's really a commercial place. This farmers market, you can get anything there, anything. Fruits, vegetables, baked goods, jellies, jams, like everything you can get there. We have so much. But it's so commercial. It's more like the prices are even more expensive there because it's huge tourist trap, and I mean there should just be an easy way for like the community to go to local farms and purchase some milk at a normal price, instead of going to Giant where it's 4 times as expensive.
Is that right?
I just went on a tangent.
They attempted to contact you by phone and letter, and they were not able to contact you with either of those methods. Is that correct?
Yes.
And they sent you an email, but you did not respond to that email. Is that correct?
Yes.
Nothing further on a factual basis.
Mr. Gerber,
No questions.
the court will find the defendant has tendered a knowing voluntary admission based on the factual basis. The court will find the defendant has violated the terms and conditions of his placement on probation by failing to maintain contact with probation as required. Transfer arguments on sanctions, please.
Thank you, Judge. Judge Phillip really just admits responsibility for his actions. He said when he filled out the paperwork, he did not put down his apartment number, and he did not put down the correct phone number, the ending of his phone number. And that he did not get the email on time. His email address was correct, but he didn't get the email. He wasn't checking his email address. And so it was his responsibility. And he says that, he did not follow through as he was supposed to. And then he says that he was going through some mental health issues and just kind of got scared and just made the wrong decisions. Didn't have a job. Everything was just kind of going downhill for him, and it wasn't. He just felt like he was in a hole and couldn't figure out how to get out of it. But he said that he turned to his family. He said he's been speaking with his mother, that he has a job available to him, that she's helped him secure a job at the same place where she works. And that he's also been studying for his GED. He has an appointment to get back into therapy. And so he's with the contact that he's made, reconnecting with his family, specifically his mother. He's kind of getting back on track with her help. And so he's been in custody since August 25th. I believe that was, I can calculate the days on this one. I will calculate the days on this. Should just, what we're asking for is that he be given another chance at probation. Probation's recommending that as well, in addition to some CALP weekends. So that would be our recommendation as well.
Thank you, Mr. Page. Is there anything you'd like to say on your own behalf?
Yes, I would like to apologize to the courts for not handling my responsibilities like I should have, and I am taking accountability for my mistakes. And that if I'm given the chance, that I will strive to do better for myself and for my kids. Because I really miss them a lot, and I know they need me out there and not in here. So I need to start doing better.
And where is your therapy? All
Hold on.
right, thank you. Arguments from the state, please.
Your Honor, probation has recommended, a return to probation on zero tolerance, and obviously the state is aware of, that this court is not, you know, I guess keen on zero tolerance. So the state is, I guess, in agreement, with a recommendation that Mr. Page return to probation. I would ask for, 2 CALP weekends, but again, would defer to the court.
All right, thank you, Mr. Groover. Mr. Page, just to pick up on what Mr. Groover said, I think that there's a lot that can be said about zero tolerance on probation or placement. And I certainly don't fault your probation officer for asking for zero tolerance. But the reason why I take issue with it is it's not an evidence-based practice. There should be use of a sanctions and incentive grid to try to get you to comply with probation. Perhaps the reason that probation officer made the request for zero tolerance is because you just hadn't followed through with probation at all. And Mr. Page, I think that more likely than not, you just kind of ignored it and hoped it would go away. I don't know how else to characterize it, because the fact that you provided a wrong address, phone number, and didn't check your email just tells me that you just kind of checked out. Mr. Page, hopefully you can get things back on track so that you can go through whatever services will benefit you and in turn benefit your kids. As you stated, that they need you and they need you to be a fully functioning person and dad. You certainly need to be out there earning support to help pay for them as well. So I agree with your state's recommendation for a sanction to your admission to the violation of probation. That you be placed back on probation. If your probation officer decides that she's going to file a violation, if there is another violation, that's up to her rather than handling it internally. But I will order that you serve 2 community-oriented project weekends. And transfer, did you calculate the time?
43 days.
Ruh-roh, Raggy.
So,
Ruh-roh. Is my mic not working? Good. Does it sound like poo? I almost said it. Almost swore. I don't want to do that. Don't say shit on my channel. Is it bad? How bad is it? Our farms aren't owned by third person. I mean, I'm not going to say there's no farms owned by third person in Lancaster, but we have a lot of family-owned farms. A ton. A mega ton. I mean, in Lancaster, it's just a lot of farms. And a lot of Amish-owned farms. A lot of Mennonite-owned farms. But man, I just wish we could buy the food from the farmers locally better. Wish there was a better way to do that.
I will order as a sanction for your violation that you serve 51 days at the Elkhart County Correctional Facility. I will award you credit for 43 days served plus equal due time credit. And for the remaining portion of that sentence, I will authorize alternative placement through Elkhart County Community Corrections Work Program weekends. We've talked about their orientation. Is it Tuesday or Thursday?
We are dangerously close to crossing a line, so do not cross that line. I understand what you want to say right now, but not here. And it's, whew, we just we don't want to get political right now, today, in this chat. We want to watch court videos.
Talked about it not too long ago,
It's two.
Tuesdays at 6 o'clock.
Tuesdays at 6 o'clock. So I will order the report for an orientation at Elkhart County Community Corrections on October 28th at 6 p.m. Ms. Schweinsker is writing that date and time down in your brochure. I will also order that you contact probation within 48 hours of your release. I am going to order that you show up in person and meet with them. And while we have you here, what is your address?
It's 1206 Bur Oak Place, apartment D.
D is in David.
Yes. There's no numbers on it. It's just apartment D.
And what is your current phone number?
574-309-0379.
All right. The court should the appearance of the public defender's office is withdrawn and any future hearing dates are vacated. Ms. Schweinsker, anything else?
You said come to probation within 48 hours
Yep.
of release.
And so I'll be released today.
Yes. And if you have no other holds, you will be released today.
Probation takes. It's on this floor.
You remember anything else?
No, Your Honor.
Good luck.
Thank you. Thank you, Your Honor.
Dean Stelper.
This is cause number 2001-2204-582, State of Indiana versus King Stopper. Mr. Stopper, raise your right hand, please form. Do you swear or affirm under the penalties of perjury the testimony you provide to this court with the truth?
I do.
Thank you. Go ahead and have a seat. And please tell me your full name.
Kane Hunter Stopper.
Thank you. The court shows that the defendant appears in person and also with Attorney Kelly Schweinsker. The state appears by DPA Colin Hoover. And I show that we are set today for further proceedings on a violation of probation matter. Schweinsker.
Thank you. Who admit to the probation violation? We have an agreed recommendation, Judge.
What's the agreed recommendation, please?
The agreed recommendation would be he would be given credit for the time that he served in custody. That's August 15th to today's date of October 6th. I'll calculate the days. And transfer his probation back to Indiana, and he'll be placed back under probation supervision. His probation was transferred to Michigan.
Mr. Groover, do you have anything to add?
That is what our agreed recommendation is, Judge.
All right, Mr. Stopper, we'll talk in just a few moments about any effect of that agreed recommendation in just a few moments. But before we get to that point, sir, do you want to admit today that you violated your placement on probation? And what I'm doing right now is I'm just going through an advisement of rights with you.
Okay.
So I'm just making sure that that's what you plan on doing today.
Yes.
Mr. Stopper, do you understand that you are not required to admit that you violated your placement on probation and that you can instead require the state prove that you did so?
Yes.
Mr. Stopper, in the event that you deny that you violated your placement on probation, we will have a hearing. At that hearing, the state of Indiana will present evidence, which typically happens through the testimony of witnesses. You have the right to confront and cross-examine any witnesses called by the state of Indiana at that hearing. Do you understand that?
Yes.
You also have the subpoena power of the court, which means that you can require that witnesses appear at that evidentiary hearing and testify on your behalf. And the exercise of that right does not cost you anything. Do you understand that?
I do.
You also have the right to have an attorney represent you at that evidentiary hearing. So that means if you wanted to have that hearing, Ms. Schweinsberg would represent you at that hearing. She would also help you with preparing for that hearing. Do you understand that? Or do you understand that even though there's this recommendation that you be placed back on probation, that I don't have to accept that recommendation, and that I can instead revoke your placement on probation and order that you serve the balance of your suspended sentence? Mr. Stoffer, based upon what we've talked about, do you still want to admit that you violated your placement on probation? Ms. Schweinsberg, factual basis, please.
Thank you, Judge Kane. Do you admit that you were sentenced out of this court April 13th of 2023?
Do.
And a term of your probation is that you were to get permission to leave the state of Michigan. Is that correct?
Correct.
Do you admit that you left the state of Michigan and went to Colorado and didn't immediately tell your probation officer that that's where you were?
I do.
That's all. Nothing further on a factual basis.
No questions from the state.
Thank you. The court will find the defendant has tendered a knowing involuntary admission based on factual basis. The court will find that the defendant has violated the terms and conditions of his placement on probation by leaving the state without the permission of probation. Ms. Schweinsberg, arguments on the joint recommendation, please.
Thank you, Judge. Kane had 5 years of probation that was transferred to the state of Michigan. He was originally put on 10 months of a tether, which he did successfully. The reason that he went to Colorado was because his mother had a stroke and he just immediately left and made his way to Colorado because she had no one
It's just a coincidence. This is Indiana.
there, no other family. He was got a phone call and he just left and then worried about things afterwards. That's what happened. And he gets extremely emotional when he talks about it, but he apologizes and apologizes for it. And I keep telling him not to do so, that he did what he felt he just was being a good son and was doing what he needed to do. He said his mother had no one at the time. There was no one there for her. And he knows what he did was wrong. He eventually let his probation officer know. So obviously this is something we don't think will happen again. And we feel that he will be successful. He was also, the reason he's gonna be here in Indiana is because he was up in Michigan, cause he had a wife there. They are now separated and that situation is over. So he has, someone here in Indiana. He's gonna be living here. He has a job waiting for him here. And, everything's gonna be fine and successful for him here in Indiana. So hopefully he'll be able to finish out the rest of his probation, which isn't due to be over until April of 2028. And he did turn himself in. He was up, when he came back into Michigan, he turned himself in on August 15th. Total days 53.
Thank you. Mr. Stoffer, is there anything you'd like to say on your own behalf?
I just want to apologize to the judge and the courts, wasting your guys' time.
Thank you. Arguments from the state, please.
Your Honor, that is our agreed recommendation. I think it's appropriate in light of kind of the circumstances. So I would just ask the court accept it.
Thank you. The court, based upon the information provided and the recommendation of the parties, will adopt the joint recommendation to show that the amount of time that the defendant has served in custody to be a sufficient sanction. Again, that's 53 days served plus statutory good time credit. The court will release the defendant back onto probation supervision and will show that the probation is to be transferred back to the state of Indiana. Mr. Stoffer, what is your address in Indiana?
It is 200 Lane, 100 Lake Charles East.
There's somebody in the audience who appears to disagree with that.
Angle, Indiana.
I jumped to your under oath. Tell me what your address is.
100 Lake Shore. 3.
Yes.
I found the mute button. Ah.
200 Lane. 46.
Somebody in the audience appears to be agreeing with the address. So,
Yes.
okay. So it seems like you get yourself in a little bit of a mess. Mr. Soffer. So the court certainly understands that emergencies arise, and it's not always convenient when you are under some type of supervision. I think that most of us would be hard pressed not to take the same action you took. However, I will also tell you that if you quickly and openly communicate with your probation officer, if you have something like that, that probation will quickly act on that. And if they file a request for you to travel, I quickly review it. Those requests do take priority in my just review all of my cases. You just really need to think about this in the future. You're not going to do anybody any good if you are in custody. So
Having the up arrow gone is a hardship sometimes. You don't realize how much you use that little button.
I will authorize your release back to probation. All right, so East Angola, is that
Steuben County.
Steuben County? Are you asking the probation to be transferred to Steuben County?
You want to transfer there or you want to come here? It'll pay a transfer fee.
You gotta pay the
It's
transfer
a one-time
fee.
transfer fee versus going back and forth.
He said
$16,000.
yes.
Okay.
He would like a transfer.
So the court will authorize probation to be transferred to Steuben County, Indiana, subject to their approval. You need to meet with probation here, Mr. Stoffer, to get that probation transferred over. So I will order that. Again, you cooperate with that before your probation is transferred, and I will order that you complete the terms of probation as specified by your probation officer. You need to make contact with probation within 48 hours of your release from the jail, and I will order that you come in person. Probation is now located in this building. I will show that the appearance of the public defender's office is withdrawn, and any future hearing dates are vacated. Ms. Reins, is there anything further?
No, Your Honor, thank you.
Mr. Hoover?
Nothing, Your Honor.
Mr. Shootman, or Officer Shootman? Oh, I'm sorry, you can't. Joe. Sorry, Joe.
Okay, before we run out of time completely, let's look at this guy. It's a new judge. Oh, I gotta move my stuff for this guy. Whoops, not you. Don't you move, judge. What's wrong with you? And he has a bow tie. So I got him. I got him. We're just gonna see some initial appearances real quick. That looks good. With a new judge. This is Colorado. Look, it says it right in the center of your screen. Colorado. So, we're going to see a new judge with a bow tie. Because that's how we roll here.
Court calls 2025 M5354 in the matter of Luis Lopez. Do you need a minute? Catch up? You'll be okay? All right. Good afternoon, Mr. Lopez.
Good afternoon. Bill Wetzel on behalf of Mr. Lopez, who appears next to me today in person and in custody. Your Honor, Mr. Lopez has been read and advised of his rights pursuant to Rule 5, and we waive any further reading or advisement of those rights. It is my understanding that he is not a veteran of the United States military, nor is he an active duty service member.
Joshua, you are a pain in the ass. Why do you keep climbing up my curtains? How do I stop you from constantly hanging on my curtains? I think you would sleep there if I would let you. Hanging on my curtains, Joshua. Josh. You don't listen to me either, Josh. Just saying.
We have no objection to the mandatory protection order as it has been tendered. And as far as bond goes, the state has stipulated to personal recognizance bond, so we are requesting that this court grant Mr. Lopez a PR bond on that basis.
Thank you, Mr. Cram. Any record?
Yes, Your Honor. I'm stipulating to a $1,000 personal recognizance bond in this case, similar to pretrial. I've been having issues accessing Denver data access right now. Given that I don't have a complete photo of his criminal history, and neither does pretrial, I'm erring on the side of caution here.
Thank you. Deputies, are you holding Mr. Lopez on any potential Denver cases? I see that he has an open case out of Greenwood Village, but it looks like it has a personal recognizance bond. So is there anything holds on him? Thank you. Just this case. Got it. Is that probation out of Arapahoe still active, or was it revoked?
My probation. So it was on the process.
So hold on one second, sir. I very much appreciate you jumping in, Mr. Lopez. I want to make sure you don't have to apologize. You're good. I want to make sure you understand. When I'm asking questions is usually to the attorneys, your attorney and the prosecutor.
Yeah.
If I ask generically to somebody else, I'll identify them. I will rarely ask you anything but a direct question as to whether you understand something, because everything's being recorded. Anything you say can be used against you. Prosecutor sits right here. So why don't I give you the time to talk to your attorney, and then we'll move forward, okay? It's not going to affect your bond.
Maria, yum. Thank you. Took us a long time to get the food this morning.
Ready, Your Honor.
All right. Mr. Lopez, did you have enough time to talk to your attorney?
Yes, sir.
All right. Mr. Cram, were you able to determine whether that probation in the Arapahoe felony case was revoked?
Yes, Your Honor. It was revoked and terminated as unsuccessful with only jail time.
Thank you. All right. So, Mr. Lopez, I've reviewed your case. I've heard arguments of counsel, a stipulation there too. I'm authorizing a personal recognizance bond in the amount of $1,000. You do not need to pay that amount to be released. Your return to court is on November 3rd at 8:30 in Division 404. That's an out of custody return date. Do you promise to return at that date and time?
Yes, sir, I did.
Thank you. Do you understand you've got a Greenwood Village case and that has a warrant? You have a personal recognizance bond on that, but you have to get back there as well.
Yes.
Ooh, good
Thank
luck
you, sir.
with that,
Is
Kelly.
that what the court date is that you just gave me for November 3rd, or is that something separate?
No, I don't know Greenwood Village's court dates. November 3rd is our court date for this Arapahoe County case.
Thank you, sir. And how would I go about getting the information to handle that within the village?
The young man to your left is a great resource. If he doesn't know, I know he can find out.
Thank you, sir.
You're welcome.
Take a seat over there.
Yeah. Yep.
Nachos.
Your Honor,
Yes,
we can call
sir.
Mr. Herring.
Court calls 2024 M 3953 in the matter of Huey Herring. Good afternoon, sir.
Good afternoon.
Your Honor, I have tendered a signed mandatory protection order to your clerks with no objections. We waive formal reading and advisement. Mr. Herring represented to me he is not a veteran of the U.S. Armed Forces, and it is my understanding that the state has stipulated to a personal recognizance bond in this case.
Thank you. Mr. Cram?
Yes, Your Honor. I'm just requesting a $1,000 personal recognizance.
Thank you. Compliance with statutory requirements, a condition of bond?
Yes, sir.
Question, yes. Thank you. Mr. Herring, did you understand the mandatory protection order that you reviewed with your attorney?
Yes, Your Honor.
Do you understand that if you violate the conditions of the mandatory protection order, you face potentially rearrest, new charges, and contempt of court?
Yes, Your Honor.
Glad to hear you understand. I'm going to issue that mandatory protection order as tendered. Sir, I've reviewed your case. I've heard arguments of counsel, a stipulation there too. I'm authorizing a personal recognizance bond in the amount of $1,000. You do not need to pay that amount. You have some registration requirements under law. You have to comply with those. as a condition of your bond. You have 48 hours to do so, okay? Do you understand? Glad to hear it. Your
Oh, he moved. There was a guy in the end that was like hanging, and then as soon as I was gonna say someone needs to check on him, he moves. I paused my stream for no reason and spoke during my stream for no reason.
return to, oh, I'm sorry. Mr. Herring, your return to court out of custody is on October 17th at 10 a.m. in Division 306. That's the third floor of this building. Do you promise to return to court at that date and time?
Is that Tuesday?
I don't know when October 17th is. Let me check the calendar. No, sir, that is not this Friday, next Friday, but the Friday after.
Okay.
About 2 weeks.
My Dr. Martha sort of comes to my house.
Weeks in a day, okay?
Okay.
Thank you, sir. It's going to be written on your bond paperwork. Yes, compliance with statutory requirements. I'll message that to you.
I don't know. I have a general question. Lidocaine patches, are they like, they're certainly not like habit forming, or why can't everybody have them? Why can't everybody have lidocaine patches? Why do you need a doctor's prescription for that? I get it. If you put like more than 3 on in 12 hours, then it could be dangerous. But if you take 12 Tylenol at once, it's dangerous. So we do have over-the-counter medications that are dangerous if you use them incorrectly. Why can't everybody have, guys, they're wonderful. They're amazing. Okay, I get it. If you mask pain, then you might hurt yourself even more. But Tylenol is proof that everyday people get rid of their pain. Like, why can't these patches be available to everyone? I don't understand why you need a doctor's note for them, because they're really good stuff.
Yeah. Yes, Mr. Wetzel.
Your Honor, we're ready on the matter of Manza Miller.
The court calls 2025 M5349 in the matter of Manza Miller. Good afternoon, sir.
Bill Watts on behalf of Mr. Miller, who appears next to me today in person and in custody. Your Honor, Mr. Miller has been read and advised of his rights pursuant to Rule 5, and we waive any further reading or advisement of those rights. It is my understanding that he is not a veteran of the United States military, nor is he an active duty service member. Mr. Miller has been read and advised of the mandatory protection.
You're right. If you use them wrong, you stop breathing. You're right. You're 100% right. But there's a lot of over-the-counter stuff that if you use it wrong, you're unalive anymore.
Order, and we have no objection at this time as far as bond goes. The state has stipulated to personal recognizance bond, so we are requesting that this court grant Mr. Miller a PR bond.
Thank you. All right.
Why does Colorado have an upside-down smiley in the middle of their red eye?
Mr. Miller, did you understand the mandatory protection order you reviewed with your attorney? Yes, glad to hear you understood it. Do you understand that if you violate any of the conditions of that mandatory protection order, you face potentially rearrest, new charges, and contempt of court? Yes, glad to hear you understand, sir. I'm going to issue that mandatory protection order as tendered. I've reviewed your case. I've heard arguments of counsel, a stipulation there too. You okay, Mr. Miller? Sort of like you looked like you zoned out there for a second. You're with us right here? Okay, yeah, just because this is what I saw, your face kind of leaned back and turned away. I was just concerned you were having some problems, as long as you're okay. So I was
I am
saying
not
that
okay.
I reviewed your case. I've heard arguments of counsel, stipulation there too. I'm authorizing a personal recognizance bond in the amount of $500. You do not need to pay that amount to be released. Your return to court is on November 7th at 10:30 in Division 405. That's the 4th floor of this building. Do you promise to return to court at that date and time? Okay, thank you, sir.
Test him. At least he brought him back to reality.
And Your Honor, we can call Mr. Hicks.
Oh, I want the other
I'm
guy.
sorry, didn't hear the last name. Hicks.
I want
The
the other
court calls
guy.
2025 M5350. The matter of Nathaniel Hicks. Good afternoon, sir.
Your Honor, we waive formal reading and advisement. As to the mandatory protection order, we would like to note our objection to box number 2 as a preliminary matter. Mr. Hicks represented to me that the mortgage for that shared home is in his name and he is using his VA benefits for that. He is a veteran of the U.S. Navy. He served for 6 years in Afghanistan. Your Honor, he also noted he has nowhere else to live. His children live there. He lives there. All of his belongings are there. And he additionally noted that the alleged victim in this case currently has 2 other houses, and she has been staying at one of those 2 houses rather than that shared family home. It's also my understanding that they are in the midst of a divorce. There is a dissolution of marriage case 25 DR 31630 out of Arapahoe that is currently pending.
Before you continue, 25 DR 3160.
31630, Your Honor.
30, thank you. Go ahead.
Your Honor, additionally, we believe that the alleged victim will continue staying at that other residence. Therefore, there is not a particular risk to her. We would ask for that box to be struck. In the alternative, we would be asking for a civil assist if the court is disinclined to do so. Additionally, as to box number 3, the alleged victim here and Mr. Hicks share 3 children together. It's simply unrealistic for them not to be able to communicate nor to see each other regarding those children. So at the very least, we are asking for incidental contact for child exchange purposes, as well as electronic communication regarding those shared children. And it's my understanding those are Mr. Hicks' biological children, and he does have that right to parent.
Prove it.
Thank you.
And lastly, Your Honor, the state is stipulating to a personal recognizance bond in this matter.
Thank you. One moment while I look at the DR case.
I want to see this guy. Come on, hurry up. I hope we get to see him.
Doesn't look like from the Register of Action that there are temporary orders in there yet. I see a case management order, but that's all I see. As to your understanding, Ms. Ross, has the family court ruled on the who gets which home?
Your Honor, it's my understanding they have not yet. I am seeing the next event in that case on October 10th at 11:30 a.m.
I see that.
So I imagine there will be continued proceedings there, but it's my understanding in speaking with Mr. Hicks that there has been no formal ruling regarding that house.
Same here,
Thank you.
Terry. Same
Mr.
here.
Cram.
Yes, Your Honor. Under the Victims' Rights Act, the people have been able to get in contact with Ms. Hicks. She's requesting no contact in this case, including child care.
Josh, how many houses do you have? Be honest. Don't lie online.
The people are actually just awaiting some more information as to the children's names. They were witnesses and involved in the underlying offense here. We will be adding child abuse charges down the road as soon as we have enough to actually add them. Given that the people are requesting boxes number 2 and 3 to remain checked, and the victim has no opinion as to bond, the people are requesting a $5,000 personal recognizance.
Thank you. Mr. Hicks, did you understand the mandatory protection order that you reviewed with your attorney?
Yes, Your Honor.
Do you understand that if you violate the conditions of the mandatory protection order, you face potentially rearrest, new charges, and contempt of court?
Yes, Your Honor.
Glad to hear you understand that. So I'm going to authorize the civil assist to allow you to go to the home to collect your personal uncontested belongings. You have to schedule that with the police or the sheriff. Should you find out that Beth Hicks is not at that home, then the law wouldn't prevent you from, and the mandatory protection order wouldn't prevent you from staying at the home. If she's there,
Josh, if you had more than one, I was going to ask for one. I'm just telling you now, I was going to ask you for a house. Josh, but it's not for me. It is for me. But it's for we. If you had more than one house, I was going to suggest you give one to Court Vibes, the group, collectively. You can still be the owner. But that way, we all have somewhere to get together. We can take vacations there and hang out and watch court videos and drink beer. But you only have one house. Hey, Josh, that brings me to another point. Can you buy another house? It could be a trailer. We're not proud. Just get a trailer somewhere. It doesn't have to be in Utah, too. It could be anywhere you want. If you're going to buy it, I guess you should be able to pick. It would be nice if you could buy one on a beach near a bar. Josh, buy us a house. Buy us all a house so we can meet up at the house and hang out there. Come on, Josh, do it. Come on. How many times, how many months will it take me to get Josh to buy a house? I'm just going to ask him every day to buy us all a house, guys.
you cannot be there. Does that make sense to you? You understand. I'm glad to hear you understand. Ms. Hicks has requested through the prosecution zero contact. The prosecution has informed me that the allegations purportedly happened in front of your children, and that they may be filing additional charges. At this time, I'm not going to modify the mandatory protection order to allow for any contact. Your attorneys know how to address that at your next court date. Certainly, you could address that at your next court date, which is, I agree with your attorney, in the family law case on October the 10th. That court knows how to talk to the...
Tona, send him dinner. Tona, DoorDash him dinner real quick, and he'll buy us a house. This can't fail. This is a great plan.
criminal courts to at least let them know what the orders are. In other words, if there's an order entered in the family law court, the criminal law court can see it. Do you understand? Okay. So I'm going to issue the mandatory protection order only with the civil assist. I've reviewed the case. I've heard arguments of counsel, position of the protected party, and I've reviewed the dissolution of marriage case register of action. I'm going to authorize a personal recognizance bond in the amount of $5,000. You do not need to pay that amount to be released. Your return to court is on October 31st at 9:30 in Division 301. That's the third floor of this building. So you've got two cases in at this courthouse. The family law cases are in the other building, building 2. Do you promise to return to court at that date and time? Okay. One last time, so it's super clear. Mandatory protection orders remain in place with all the conditions unless and until a judicial officer changes them. So you could be in a strange position that the judicial officer in the family law matter issues some temporary orders that are different than this mandatory protection order. This one, if the more strict, and your attorney can give you the more information and advice, but the strictest order applies. So don't get into this situation of, oh, well, the family law attorney said, judge said I can do this, but the criminal law judge didn't. Does that make sense? All right. Glad to hear it. Thank you, sir.
I really, when I show a new judge, I really want to test them. I wish I could throw a subset. I wish I could throw a Karen at these new judges so that we can really test them out and see what they're really like. But no, I have to hope and wish. This is bad.
Yes, Mr. Wetzel.
Your Honor, we're ready on the matter of Timothy.
Josh, it must have a pool and a hot tub. Even though it's by the beach, which is water. I saw a story yesterday. It's sad. This is a sad story. I'm just telling you now. But there's this house that you can rent. I think it's in Africa. Okay? And it's out in the ocean. And the master bedroom is all underwater. And it has, like, you know, the glass. So you rent, we're just going to say like a B&B. All right? So the main house is like floating. It's all wood, like a shack or a shed, but it's very pretty. And that's the main area. And then you can go up the steps to this roof, which has this big bed on it that they call a couch, but it is a bed. It's like a king-size bed that they call a couch. It is not a couch. But you can watch the stars or whatever. There's no one anywhere near you in the ocean. And then you go down, and the master bedroom is underwater. Well, this poor guy took his girlfriend there on vacation, and she was in the master bedroom underwater, and he jumps off the side with this note that he had in plastic baggie, and he held it up to the window. And it's like, I can't hold my breath long enough to tell you all the ways that I love you, blah, 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 blah. Will you marry me? And she's filming it. She got pictures, like she's recording this video and taking pictures, you know, from the video. And then he pulls out this ring from underwater and he holds it up to the glass. And she runs upstairs and she can't find him. So she runs up to the roof, to the couch. She can't find him. So she starts screaming, help, 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 but there's no one around. But finally there's these fishermen that come. He stayed under the water too long and drowned. Maybe we shouldn't have a hot tub or a pool because people are stupid. Maybe we should just have a big bubble. Josh, can you just buy us a big bubble instead? With absolutely no water. Because people are stupid. We don't want anybody getting hurt in our brand new house. I think you should buy us some of those huggy coats too. The white ones. That way we really, really can't get hurt. I know, isn't that horrible? I don't know if we should have a hot tub. I don't want anybody to get injured. But, alright, let's see if this last guy is interesting. Come on, guy, get up. Go in front of the judge. My stream is almost over and I want to see you.
The Elrod.
Court calls 2025 M
Here he comes.
5345, the matter of Timothy Elrod. Good afternoon, Mr. Elrod.
Good afternoon.
Bill Lutz on behalf of Mr. Elrod, who appears next to me today in person and in custody. Mr. Elrod has been read and advised of his rights pursuant to Rule 5, and we waive any further reading or advisement of those rights. It is my understanding that he is not a veteran of the United States military, nor is he an active duty service member. We have no objection to the mandatory protection order as it has been tendered at this time. As far as bond goes, the state has stipulated to a personal recognizance bond with monitored sobriety as a condition of bond. We are requesting that the court grant Mr. Elrod a PR bond with no conditions attached to it other than a promise to come back to court. It's my understanding that Mr. Elrod has lived in the Denver Arapahoe area for the past 9 years and has a strong social support group that can help him remain sober and come back to court. Additionally, he has shared with me that he knows how to use the RTD system. As far as I could see on data access, there were no drug charges on his record, and the pretrial services report indicated that as well. He has also shared with me that he has recently gotten a cell phone so he can receive text reminders to be able to be reminded about future court dates to ensure that he is on time for those future court dates. Additionally, Your Honor, as I'm sure the court is well aware, UAs would likely be the condition for monitored sobriety. Those cost anywhere from,
I'm well aware of the costs.
those are quite costly. Mr. Elrod is currently struggling with employment issues at this time, and that would present a very large financial burden if he were required.
Oh, no, Sherry, look what happened. Sherry, John Doe left. Son of a gun, that's just rude.
To be taking UAs, and given that bond should be the least restrictive means possible and there are no drug charges that we can see on Mr. Elrod's record, we are requesting that the court grant a PR bond with no conditions of monitored sobriety attached to it.
Yeah, but okay, but oh, you took it away. Why would autocorrect do Elrond? I love it though. Like, why would it hit that? You must have typed that word in your past. For what reason? Oh, never mind, Josh. We need a pool and a hot tub because Chinny's right. We can just use scuba gear and then we won't drown. That's a great idea. Or at least one of us snorkel. At least a little snorkel.
Thank you. It appears that Mr. Elrod is is out on summons on an Arapahoe trespass case and on warrant out of an Aurora Muni case. Have you informed Mr. Elrod regarding the consequences of new allegations when you're out on summons on one case and potentially on warrant out of a municipal case?
Yes, Your Honor.
Thank you, deputies. Are you holding Mr. Elrod on that Aurora Muni warrant? Thank you. Mr. Cram.
Yes, Your Honor. My request is only a $500 personal recognizance bond with pretrial release and monitored sobriety, given the allegations.
Thank you. So, Mr. Cram, it's the court's understanding that currently pretrial supervision monitored sobriety is near capacity. Since this is a first allegation of a substance abuse case, while the court would be inclined to grant it, I understand that pretrial supervision with monitored sobriety is, again, at capacity. So the court is inclined to not impose that, but do the phone check-ins and raise the PR bond. Any objection from the people?
No objection, Your Honor.
All right. Mr. Elrod, did you understand the mandatory protection order that you reviewed with your attorney?
I did.
Do you understand that if you violate the
Bondi.
conditions of the mandatory
Bondi
protection order,
rescue.
you face potentially rearrest, new charges, and contempt of court?
I do.
All right, I'm glad to hear you understand that. Because you're out on a summons, because you have a warrant, I have concerns about you being out in the community, but the prosecutors agreed to a personal recognizance bond. Your attorneys are asking for that, and I trust the attorneys before me, so I'm going to agree to that. But rather than pretrial supervision with monitored sobriety, you might have heard me talk to your attorney and the prosecutor, they're at capacity. It's your first offense of that nature, to my knowledge. So rather than impose that, I'm going to impose pretrial supervision phone check-ins. Your attorney says you have a phone. That way I know that you're getting those reminders to come to court. Because I have little concerns about you coming to court when you have a failure to appear this year.
Bondi.
But not imposing the pretrial supervision monitored sobriety, because I do hear what your attorney is saying about the costs that you might not be able to afford. So I'm raising the bond from guidelines of $500 to a $1,000 personal recognizance bond. You do not need to pay that amount. You do have to report to pretrial supervision so that you can get the information for the phone check-ins. Your attorney's going to give you this card. It says you have 48 hours from your release to do it. Do it sooner rather than later. If you can get there today, might be a little close, but sooner rather than later. Do you understand?
So am I being let?
You're going to, on this case, you're going to be released on a personal recognizance bond. You've got a warrant in another jurisdiction. Your attorney will advise you as to whether to sign the personal recognizance bond until you can address the warrant. Do you understand what I'm saying? Do you understand that 48 hours from your release, as per the card you're about to get, you, as a condition of your bond, have to go to pretrial supervision to register for their phone check-in programs? I know you're nodding up and down. Yep. Thank you, sir. All right, Mr. Elrod, your return to court is on October 20th at 9:30 in Division 404. That's an out-of-custody return. Do you promise to return to court at that date and time?
I do.
Thank you, sir.
I do have a couple of questions.
All right, so Mr. Elrod, I'm happy to answer any of your questions if I can. You need to understand everything's being.
Judge, shut up. Shut up, Judge. Put your finger down. Let him ask his questions. I need to know what his questions are.
Recorded. Anything you say can be used against you. Prosecutor sits right there. So typically, best practice is to ask your attorney, and then your attorney can let me know, okay?
No. Judge, that was me.
Hey, Mr. Elrod, you might want to whisper. I can hear you.
Yes.
Was that it, Arepa? Thank you. Ms.
Well, that was rude and mean. That was a mean way to end that stream. I wanted to hear his questions. I bet they were excellent questions. I bet they were high quality questions and we missed it. It's fine. How is hubby? This stream is ended, so I just gotta know. How is hubby doing today? Are you at the hospital still? Oh yeah, we should do that. One of you should either call in or use your camera. I mean, and come on the stream with me. I know no one's going to, but you should come on the stream with me whenever you want. Just tell me in Discord and I'll set it up. And we could mute him and we could be them. Like, you can be the judge talking with his hands. I shall be the prisoner. Yes. Ah, damn it. Alright, at least he's getting cared for at the hospital. And he's got you. He's got you like a little chihuahua making sure everything is right. Without you being there, he would be in trouble. If I ever go to the hospital, I want you to come with me. I hope he feels better soon. Alright, the stream is over. It's time to start OJ. Ha! It's time to start OJ. I can't wait. I'm loving OJ right now, guys. This is great. I will see you guys again very soon. Oh, it's time for the outro. Jude, this outro. I love it. I love it. Have a good day, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.